Good morning and welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR, and we are very happy this morning to be joined by Megone Trewick. She is with the law offices of Bryan, Fagan, and she is going to talk to us about a very, very important topic today, probate and estate planning for realtors and in real estate. So thank you so much for joining us.
My pleasure. My pleasure.
Absolutely. So before we get into everything, tell us a little bit about yourself, who you are, and what you do.
Yes, my name is Megone Trewick. I am the director, as you said, with the law office of Bryan Fagan. But who I am, first, I'm a wife, I'm a mom, I'm a Christian, I'm an attorney. And I take estate planning very seriously because I know how instrumental it can be for anybody's life. I know the horrors of not having an estate plan, and I also know the pleasures and the seamlessness that can come from proper estate planning. And I've devoted my life, in fact, my first job, fresh out of law school, was in an estate planning probate firm, and I followed that through line to where I am right now.
Well, that's wonderful. And you are very passionate about this topic, and you do a lot of videos, some great stuff. I'm sure we'll talk about it more later.
Yes.
Some very entertaining things going on over on your social media outlets. But let's dive into today's topic. And really just the first key question, I think, is why are probate and estate planning, why is this so important for realtors and really just business owners?
See, what I've seen over the years, business owners, I'm also a business owner. I have my different business. My husband has a business. And for all of us, we are so headstrong on getting the next client, building our empire, just taking over the world. But we never realize that our lives are finite. And because our lives are finite, we have to plan for what's going to happen when we reach the end of life, if we fall, if we get sick, and also what happens after we pass away. Many of us devote our lives to a business that ends when we end. And that's the saddest thing, because the accumulation of your life then gets just broken down into its individual piece at the end of your life. And you really don't leave that legacy for your loved ones that you really want. As a realtor, as a broker, as an entrepreneur, you have to think about your succession plan. What's that gonna look like? What's going to happen if you become ill? How is your business going to be run while you can't run it? Have you set up things in place wherein what you've worked so hard for continues and actually does what you intended it to get to achieve when you set out?
Wonderful. And I imagine this is likely, and you probably hear this all the time, this is probably a topic that many people don't want to get into because, like you said, it's something that's unfortunate, but it's so important for all of the reasons that you just mentioned.
Exactly. I tell people all the time, estate planning is for the living. When you talk about estate planning, first of all, people say, "Oh, I don't have an estate. Why am I planning? I don't have anything. I have one house and my house is going to go to my child when I pass away. Why do I have to do anything?" And I say to those people, estate planning is for the living. Probate is for the dying. Okay. And so while you're living, while you're doing your business, you're selling your house, you're building your empire, you're building your team. Those are the things you have to plan for. What happens if you get sick? Who is going to take over? How is your business going to run? Did you set up your business as an LLC? Is it a partnership? How is the partnership structure going to move on? How is it going to be divided? If somebody gets a divorce, is your business going to be dissolved? Estate planning is business planning, life planning that takes you to probate to hand the baton on to your children or whoever you set up.
Okay.
So,
Yeah, very good. So what are some common estate planning mistakes that you've seen?
all right, I'm talking straight to my realtor friends right now because I became a realtor back in 2008. Now I'm an attorney. Now I practice estate planning with an eye on investors, with an eye on people who want to enter into flips or whatever like that. So I'm speaking to you straight. Many realtors think that if you buy a house and you do if you take it on in the entirety, or you're joint owners with the right to survivorship, then you don't need a will. Then you don't need a trust, because if I pass away, the next person, the person I own it with, is going to take. Well, what if you both pass away? What if you had bought that house with your business partner and you're like, it's fine, my business partner can get it. What if your business partner passes away? None of you have an estate plan. Both of your estate has to now go to probate before that house gets divided to your loved ones. And if you're in the middle of a divorce and you own that house with your business partner, what does that mean? You didn't set up the proper plan in order for division, in order for the seamless transition of your business. That's the first thing. People buying houses, tenants in the entirety, or joint tenants with right of survivorship. I had a young man who came into my office the other day. Totally, I'm not gonna. You won't know it's him. The store has been sanitized enough so you don't. Both parents passed away. However, this was his mom's second marriage. She bought the house, joint tenants with her husband. Both of them passed away. They're coming into the property. She put all her life savings into this house. But now her only son is not going to share as how I know she would have wanted. The husband was married before. He had 2 children. They have been married, paying off this house together, put her entire life savings in to buy this house. And now when they are both passed, this house that I know was her nest egg, that she probably wanted to pass on to her son, is now going to be divided by 3. I don't think she saw that coming. I don't think she saw that. And for a lot of us, we're like tenants in the entirety. We're gonna own it, joint owners. I just need to put my kid's name on my bank account. That's one of the things that I saw, putting your children's name on your bank account. You put your child's name on the bank account, and then a creditor comes for your child. What do you think is going to happen to your money? There are many other ways that you could have done it. Your child will be protected. Your estate will be protected. And with a good estate plan, it doesn't have to be me. Talk to any estate planning attorney, a good estate planning attorney, and they'll help you set up your business in such a way that you protect your loved ones, you protect yourself, and you protect your future.
Wonderful. So thank you for sharing those common mistakes. What about misconceptions? Are there any misconceptions around this topic?
Yes. Main one, I'm not rich. Estate planning is only for the wealthy. Estate planning, I love to tell people, and I love to tell you that I love to tell people. But I tell people all the time, estate planning is for the living. Warren Buffett has an estate. You have an estate. The only difference is the value of those estates. But everyone that's breathing have an estate. If you may think that you have nothing. I rent, I only have my car outside, I have a couple $100 in the bank account, I don't need an estate plan. I ask you, do you have children? What's going to happen to your children if something should happen to you? They are your estate. They're the most valuable part of your estate. So of course you have an estate and you need a plan for that. You have to be thinking, who will be the guardian of my children if something should happen to me? If the other parent is not in the picture, if the other parent has nothing to do with you, and then you pass away, who is going to make those medical decisions for your children? Or even you? You just have a stroke, you're in the hospital, you're comatose now. You have minor children, and you're now in the hospital. Who is going to make those decisions for you? What have you put in place so that can be taken care of? That's an estate. And I guarantee you, you would value that estate higher than you would value Warren Buffett's millions.
Okay. And these are such good points, and I'm so glad that you're bringing some light to them. I wanted to share just a quick comment and a question that came in. And if you have any questions, please type those in, and we will get to as many as we can. This was in relation to the story you just told about the property being divided by 3 instead of 1, which would have probably been the initial intention. Roxanne said, I have a client with a very similar experience. So it does, again, leading into the idea that this is common, that people aren't protecting their estate. Zelda asked a question here. She said, so how should we set up a bank account to protect our children?
Okay. Great question, Zelda. First of all, if you have minor children, you can't leave money outright to them. They're minors. They can't contract. They can't hold property. So what do? When you have minors, you have to really start thinking about how to use a trust. How to use a trust to effectuate what you would want to have done. If you have minor children, create a trust. Make the trust the beneficiary of that bank account. And first of all, disclaimer, these are not legal advice. Speak to your particular attorney to make sure that the situation matches yours. But generally, so take my comments generally. Generally, a trust is what you want to create. You create the trust, make the trust the beneficiary of your bank account. Then you make your minor children the beneficiary of that trust. Within that trust context, you can set up whoever you want to manage your trust for the benefit of your children. So if that's your grandma, if that's your mother, if that's your aunt, that's your uncle, that person will be the trustee of that trust. Something happens to you, that bank account is now owned by the trust. Your uncle, your aunt, whoever that trustee is, can grab those assets. The assets will now be in the trust and manage those assets for the benefit of your loved ones. No court involvement. Nobody has to know what you have. This is a private affair. You keep it private. Your creditors won't know. The ex won't know. Nobody will know what you have. And your children's privacy can be protected. And you get to take care of them. That's the best, cleanest way to take care of that.
Okay.
Don't put them on the account though, Zelda. You don't want them to own the assets with you because the liability comes with that.
Okay, very good. And this question actually came up twice. Both Diane and Shannon are asking, what is the average cost to set up a trust? And do you have to use an attorney to set it up?
Okay. First of all, you don't need an attorney to set up a trust. Would I recommend it? Never. I would never recommend that you go on LegalZoom and download something or go on Google and download a trust. Why? Because there are dozens of different type of trusts, and each trust needs to be specifically tailored to your needs. If you go and you pull down a regular revocable trust online, does it talk about what would happen if you become incapacitated? Does it set up the guardianships for your children? Does it talk about insolvency? Does it give creditor protection? If you have older kids, does it talk about divorce protection, creditor protection, remarriage protection for all those people who may be passing away and want to make sure that those assets don't get taken in a new marriage? The regular trust online doesn't have that. And unless you're speaking to somebody who is going to tailor that trust for you, I would not recommend it. In fact, I would run from it. I would rather you go talk to somebody before you create a trust, or take the document to the attorney. We have the law library. You can go, they have attorneys there on staff that can look at the document for you. They may not be able to give you advice, but they can look for those things. Many trusts don't have the homestead exemption capture on there. You put your property in a trust and then you think you're good. Next year you get disqualified from getting the property listed as your homestead. The generic trusts that I see don't have those things on there. So I would never recommend it. But by all means, if you're confident that you can put those things in there, capture those things, try it. I can't tell you to practice law though. You'd be practicing to do that. The price of trust change. And it matters with what your estate plan is. You may have a special needs child. You can't use a regular revocable trust. You may be on your second marriage. You may be having life insurance that you need an irrevocable life insurance trust. I don't know what your trust is going to cost because each trust is different. And if anybody is giving you a blanket price, run.
That makes sense. And actually, we did have a question about homestead. Peggy asked, wondering about how to structure a trust to protect a homestead.
Yeah, yeah. If the trust is created properly, and if you add the proper addendums to the trust, you can still claim your homestead exemption, your over 65 exemption, and so forth. You just add that language to your trust, and that's why I'm telling people stay away from the trusts that are online, because that attorney has to write that addendum for you so that you can capture that. But the trust is you. I love to tell people that the trust is your avatar. It just doesn't die like we do. It doesn't get sick and it doesn't fall into a coma. And therefore, when the trust holds it, you still get your homestead exemption when it holds it correctly. You still get your homestead exemption. You get to have your cake and you still get to eat it.
Very good. Thank you so much. So let's kind of move into realtors helping their clients a little bit. We've already gotten into that subject a bit, but just backing up a little bit, can you tell us, how is a probate sale different from a typical real estate transaction?
Yes. First of all, if the person left a nice will that got probated and you have letters testamentary, and now that executor is signing the document selling that property, that's easy. That's easy peasy. However, things start getting tricky when you have a heirship determination followed by an administration. You, as the realtor, you are saved in some respect because the court has laid out who the heirs are. The court, if it's an independent administration, then you can rely on that administrator signing the deed. When it becomes tricky is when you're using an affidavit of heirship and then you're moving forward with selling the property. When you're doing that, I say make sure you're working with the right kind of title company that's going to make sure that you're covered. For one thing, for many, I've been in Houston for a while. You can hear by my really light accent that I'm a native. I'm just kidding. But being in Houston a while, and even it happens all over the world. Grandma owned the house. Grandma had 6 kids. Grandma never had a will. She's just doing what we all do today. Oh, my kids will take my property. The kids continue living in the house. The kids have kids. Couple of those kids pass away. Those kids now take their 1/6 share, dividing that into 1/12. So you now have an amalgamation of owners for this one piece of property. Unless that title company is on point, on its knowing its stuff, making sure that they hire that investigator to make sure all the heirs are listed, and then you as the realtor is listing this property, selling this property, not knowing that there's an heir that was left off, you are going to have yourself a mess of a situation if somebody start coming out of the woodwork saying, oh, you're selling my property and I didn't get a share. And yes, there's E&O, but just the trouble of having to make that claim, having that image tarnished because you didn't deal with those intricacies. I've worked with affidavits of heirship before, but I have to say, going to court and getting that straight determination of heirship and then doing the affidavit of heirship is a cleaner way to do it. Because one, you have a court order. You're not doing the full determination. You're not doing the full administration. You're just doing the determination along with the affidavit of heirship. Those are faster, but that's a cleaner way to do it. But at the end of the day, if you're confident that all the heirs are listed in that affidavit of heirship and you're going through with that listing and that sale, you could be okay. But the best practice is that determination of heirship and then the affidavit of heirship.
Okay, very good. We do have some questions coming in, and I want to get to those, but I have one more question that I'd like to ask you before we get to some of the audience questions. And what are some, I'm saying the word questions again here, what are some questions that a realtor should ask their clients when they're selling estate properties?
Yes. Things that the realtor should ask the client. First of all, who owns the property? We assume the person that called us up owns the property. Who owns the property? How is that property held? Is it held quitclaim? Run from quitclaim deeds. Run. Don't stop and go. Just keep running from quitclaim. Well, don't run from quitclaim deeds. Tell them we have to do some cleanup before you can sell this property because
Mhm.
it can't be insured. Right. And we care about getting or commit. Well, not me. I don't get commission. You care about getting your commission at the end of the day. You don't want to put the work in to just get to closing and then you can't close. Do you own the property? That may seem juvenile, but it's the essential step
Mhm.
that you must cross. If they don't own the property, how can you as the realtor not lose that sale but try to clean it up? Do you know a good probate attorney? Do you know a good real estate attorney? Maybe you work with a title company that has that those resources that you can lean into and get. If they are not the owners, where are the owners? Can you do some of that legwork because you
Mhm.
don't want them to go look for somebody else who's going to make it easier? Can you help grab those ears together? If they're agreeable, can you get that affidavit of earship, that determination done? Best practice, get that determination of earship done, get that title cleaned up, and get it to the title company. You can do those
Mhm.
things concurrently, but you just have to make sure the other side of the sale knows that these things are being done to make sure that the sale goes through.
Okay, very good. Thank you so much. I want to look at some of the questions that have come in from our live viewers. Monique said, I have a situation where parents passed away and their daughter moved into the house. She wants to claim homestead. Does she have to go through probate to do this?
Yes, I was like this, Monique. Yeah, she has to go through probate. She may, if she's the only child, she doesn't have to go through the entirety of the probate proceeding. But if she really wants to own the home, if there's a mortgage on the home, she has to go through probate. If she's the only child, she has to do the determination of heirship. They're going to appoint an attorney ad litem to just make sure she's telling the truth. And then it's usually fast. If she is the only child, the attorney ad litem can look at it, bless it. You go do the administration and the determination same day. Granted, you still have to do the publication, you still have to do the posting, so creditors will be reaching out to her. But if she truly wants to claim that homestead and if she truly wants to hold the property in the right way, that's the way she has to go clean it up. If there's a will, that's the fastest way. If there's a will, she can probate the will as a monumental title, and then she can get the homestead easy peasy, pretty fast, much faster than a full probate.
Very good. Thank you. Another question here from Christy. Do you recommend a transfer on death deed to leave a home with a mortgage to leave to adult children?
Christy, I love Todds. I even have a nickname for them, Todds. Oh, Todd, I love you. However, when there's a mortgage on it, especially if the mortgage company is one of those smaller companies, they may call they may call that loan. And if they call the loan, then then that loved one is held in a pickle. I love that will. If you're gonna do a transfer on death deed, do a will.
Mm.
It's same testamentary capacity. You're there with the notary anyway. Do a deed. You want to do the transfer on death deed? Do a will. You do the transfer on death deed with that will. You do the will as a monumental title, and you're good to go. Refinancing becomes easier. Title becomes easier, and that is cleaned up. I love Todd's when there's no mortgage, right? Then it escapes probate.
Mm.
It escapes probate. You get the immediate step up in basis. You go right down to the courthouse. You file your new the affidavit of death, and you have the property. You just go down to CAD, HCAD, or
Mhm.
local CAD, and get the homestead exemption on the property. I like Todd's when there's no mortgage. When there's a mortgage, I like a will, do it as monumental title, and get the homestead thing cleared up nicely.
Makes sense. Thank you. Another question here from Linda. She said, can you speak, or a comment, I guess, can you speak on life estates?
Yes. Life estates are children's, especially when they're children of another marriage. That is their Achilles heel. They hate it. But a life estate can be very instrumental and very powerful in two respects. One, Medicaid purposes. If you know you're going to be filing for Medicaid, and if you want to make sure that Medicaid clawback doesn't come to your property and take your assets that you're trying to leave for your loved ones, then you may be thinking about a ladybird deed, or what we call in Texas an enhanced life estate deed. You keep the life estate in the property, and then your heirs will get, or whoever you designate will get the property when you pass away. I like those things. For one thing, if you can do it 5 years out, Medicaid doesn't even look at it. Any one of the needs-based aid you're applying for doesn't look at it. If you know it's coming 5 years out, great plan. It's revocable. Therefore, you can change your mind. You can be like, that naughty kid, I don't appreciate you anymore. Kick you out, put somebody else in. You can do that. Another life estate that you have that I see a lot, somebody who has a home that's their separate property, they get married, that spouse has a life estate in that property. The kids can't kick them out, can't sell the property. They don't even have to pay the mortgage. They just have to pay the interest on the mortgage, the insurance, and the taxes. And that's another life estate that we see commonly in our area. Another life estate, I know, that's what I'm saying. Go talk to an attorney. Don't try to practice law on your own. Another life estate is, you may see it in a charitable remainder trust, where you keep the property for the rest of your life, and then when you pass away, the property goes to the charity. You can write off the entire value of the house while you're alive, soaking in all those tax savings. The last one that I want to talk about, life estates that you set up straight out. You do the deed, you keep the life estate deed, and the remainderman is currently, so this is an irrevocable one, the remaindermen are currently placed in somebody else. People use it when they're trying to get quick cash. An investor may buy the remainder in there, or their child might have the remainder in there, and the parent keep the life estate. Life estates are still valuable. If you go to the IRS chart, it will show you the value of a life estate. So it's not useless. It's just risky.
Okay, thank you for that. Elias asked, why do some people still probate a will if it's in a trust?
Well, yes. Okay. A trust goes with a will. A will goes with a trust. I always do a trust with a will because sometimes people don't fully fund the trust. Sometimes people pass away before they fully fund the trust. And sometimes the trust is funded by the will. So let's talk about the first one. Some people have their house, their land, whatever, and they write their will. They say, okay, when I pass away, I want all my assets to go into the Megone Trewick trust. Okay. The beneficiaries of the trust are Megone's children that drew all this beautiful art you see behind me. My children are minors. I didn't want to fund the trust now with my property because I have misconceived notions that it may mess with my homestead. Maybe I don't want to be signing Megone Trewick as trustee of the Megone Trewick's family trust. Yeah, you got to sign like that, but it just is. Some people don't want that, which I'm like, it's just a little inconvenience to write extra letters, but whatever. So some people make their wills fund the trust. That's why you need to probate the will sometimes. Mm-hmm. Another time is somebody who partially funds their trust, and then they didn't grab everything and put in the trust, and therefore you have to probate the will in order to grab those assets that didn't make it in the trust. Mm-hmm. Another one are people who inherit things outside the trust. I had a lovely lady the other day who came to me complaining, oh, I have to probate this trust because uncle died and left so-and-so money. I'm like, that's a problem. That's a fantastic problem to have. Mm-hmm. So sometimes it happens. If you have an inheritance from mom or dad, and mom wrote her will and didn't put the Megone Trewick family trust as a beneficiary, instead put Megone Trewick, I pass away, yes, my children would probate my will in order to grab those assets to put it in my trust.
Okay, very good. Couple more questions I saw that came in. Good one here from Alex. Can a trust in the United States expand to property outside of the United States?
Yes, and it depends where it is. Mm-hmm. Some clients have property in places like France and so forth, and they try to use a trust to circumvent France's inheritance law. So, no, and yes. If you have a property in a trust-friendly country, yeah, you can title it in the name of the trust. You may have property in Jamaica. Yes, property in Jamaica can be put in your trust as long as it's trust-friendly and as long as you're not circumventing that country's laws. Yeah, the trust is you. Your trust is you, just doesn't age. And but it's you. It even uses your social security number. It's you. So if you
It's
can,
your avatar, right?
it's yes.
Okay, very good. Another question here from Zelda. She said, so the courts can do a determination of heirship if there is no will. And then she said, is an attorney needed to petition the courts for that determination?
Yes, yes, yes to both. Yes, the determinant heirship is done when there's no will, or if the will is more than 4 years old, and you would need an attorney for that.
Okay, very good. Monique is leading us into a question that I have for you about learning more about this. But Monique's question is: this is a lot of information. Would I hire a trust attorney to sit with me? Is that where I should start? So, kind of wanted to ask the question: if somebody maybe hasn't really started planning for the future yet, what's the first steps? How do they get started here?
Education. Educating yourself is the best tool, and you're in the right place, because if you go to www.bryanfagan.com/ep estate planning, you will find countless videos. In fact, I have an entire YouTube series dedicated to estate planning. It's bryanfagan.com/ep. Our Bryan at Bryan Fagan EP online. In fact, my name is so unique. I don't think you'll ever find a Megone Trewick anywhere else. So if you just Google Megone, Megone Trewick, and YouTube, you'll see the entire YouTube series. We probably right now well over 100 videos, and they specifically speak to trust. They specifically speak to probate. But if you don't want to do that, if you don't want to go on YouTube and then you end up in that tunnel and you just keep grabbing videos by videos, go to the website www.bryanfagan.com and just go to the practice area, click on EP. I have several videos, webinars on estate planning. I have webinars, estate planning for divorced people. Estate planning for divorcing individuals, estate planning for blended families, because those become tricky, and estate planning trust and will. So if you go www.bryan, Bryan Fagan, Fagan.com, go to the EP page, scroll down, you'll see the webinars on demand.
Okay.
Fill yourself up to the quiver with them, and then go on our Facebook page, or our we even have a TikTok page, you name it. There's a lot of education out there. That's the first thing. Then get an attorney. It's a field test when it comes to an attorney. Not everybody, some people may rub you wrong. They may be giving you the straight information, but you don't like the tie they wore that day, or maybe they have on too much bling. Just go with somebody that you feel confident with, somebody that gives you a flat fee. Don't do an hourly estate plan. Do a flat fee one that you can confidently ask questions, follow up, so that you know you don't have to be scared to call because they're going to bill you $300 for that call. Flat fee, an estate planning attorney that you feel comfortable with.
It's kind of like picking a realtor. Find somebody who is a specialist and that you get along with well, that you like.
Yes, yes.
Okay, very good. Monique said that's wonderful. And I did want to mention that we did share the web address in the comments as well. So if you are looking for that, you can find it. This, again, has been so much great information, a much needed topic, and I'm so glad you were able to take time today to join us. Is there anything else that you want to share with our audience today?
I just want you to know that don't feel bad because you may have procrastinated. The fact that you're on this call this morning says that this is something that's important to you. The next thing is to take the next step. This is a priority. I know you may be young. I know you may be healthy. Everyone needs an estate plan, and they need one today.
All right. Well, thank you again for your time this morning. This has been wonderful, and people can look you up and visit that website if they're wanting more information from you. We have them thanking you in the comments. Gabrielle said, thank you. This has been wonderful. You are amazing. So that's a great thing to hear on a Monday morning.
Thank you.
Thank you so much. Just before we go, want to mention that next Monday, we will be joined by Patrick Jankowski with the Greater Houston Partnership. He's the Senior VP of Research, and he's going to be giving us his economic outlook for 2024. Can we believe that we are already about to be in 2024? So he's going to be talking to us about economics and where are we going and how is Houston looking, and especially in comparison to other cities and the nation. So be sure to tune in next Monday at 9 a.m. Have a great week, everyone. Bye-bye.